Iconic: The Economy of Certainty, An Introduction to the Typology of Islamic Legal Theory, Aron Zysow, Harvard University, 1984, Cambridge, Massachusetts. Introduction. Continued. The line between formalists and materialists generally coincides with that between analogists and anti-analogists. One need only cite Zahirism. This follows simply from the common recognition that analogy could provide only probable results, but anomalous systems do exist. A formalist system can reject analogy if it can find a reasoned basis for distinguishing between analogy and other sources of probability. On the other hand, if the conditions for the practice of analogy are stringent enough, its results may be raised to the level of certainty and admitted into a materialist system. For the historian of Islamic intellectual history, the study of these systems of legal theory is an end in and of itself. Their identification and elucidation is as legitimate as the analogous activity undertaken in the study of Islamic philosophy, theology, or mysticism. This would be true even if legal theory were totally divorced from any other Islamic discipline, but such is not the case. The ties between legal theory and theology on the one hand and law on the other are too obvious to be missed. At least something should be said about its relation to each other. In the hierarchy of Islamic religious sciences, theology ranks above legal theory in the sense that it establishes such premises as the veracity of God that the work of the legal theorist presupposes. But the significance of theology for legal theory goes well beyond its role of providing essential premises. Legal theory and theology were both born out of the early fragmentation of the Muslim community that forced Muslims to identify and defend the essential elements of their belief and practice. The epistemological rather than the institutional basis of Islamic law testifies to this origin. Subsequently, developed theology, above all in the form of Mu'tazilism, managed to penetrate to the very heart of legal theory. The impress of Mu'tazilism can be found centuries after the high point of its influence had passed. Ash'arism and Maturidism, too, in their turn, exercised a noble, though lesser, influence on legal theory. The literature of legal theory provides new information of direct relevance to each of these theological movements. But the chief significance of legal theory for theology lies elsewhere. Legal theory can guide the historian of theology in viewing the object of his study in Islamic terms. By becoming familiar with the interconnections between legal theory and theology, he will be able to see an added dimension to the theological arguments. No longer oblivious to their legal consequences, he will not be so likely to confine his attention to the Greek precursors, but will consider the role of these arguments in their own culture. Usul al-fiqh will teach the historian of theology to read his texts with added powers of discrimination. In some instances, he will have to distinguish between the reconstructed theology of the theological treatises and the theology in use of the legal texts. In being put to use in law, theology is sometimes forced to bend, and the theologians and legal theorists, often the same individuals, were well aware of this. All of these remarks apply with equal, if not greater force to the passage from legal theory to law. I am far from thinking that the study of legal theory should be conducted apart from the study of substantive law. The theorists were conscious enough of the limitations of their attempts to reconstruct their own practice. But while it would be foolish to detach the theories from the legal system it was meant to serve, it would be even more foolish to ignore the work done by the Muslim jurists in disengaging the principles that guided their activity. Those who counsel us to do so in the name of legal science only elevate ignorance into a method. Before we can begin to determine how far the practice of the Muslim jurist diverges from his theory, we must have a far better grasp on what that theory is. It is not difficult to find statements of the most illustrious jurists testifying to the importance of usul al-fiqh for the practicing jurist. I see no reason to doubt the validity of their remarks. The primary role of legal theory for the historian of Islamic law is that it aids him in seeing law as a discipline in its own right, with evolving methods and styles. It brings the historian closer to the inner and, to my mind, more significant side of Islamic law for the outsider. It inculcates concern for system and method, not merely for the single rule of law or the single legal institution. Having immersed himself in legal theory, the student of Islamic law will come to see the law as the Muslim jurist does, and this, if not the final, is at least the first stage towards understanding. End of introduction. There is an excellent footnote in the introduction, and it's footnote number 3 on page number 9, and it gives the distinction between formalists and materialists. I will read it for you. My distinction between formalists and materialists is inspired by, but by no means coincides with Salmon's distinction between formal and material sources of law. Quote, a formal source of law is defined by Salmon as that which a rule of law derives its force and validity. The material source is that from which is derived the matter, not the validity of the law. This is based on a textbook of jurisprudence by Patton and Durham, 4th edition, Oxford University Press, 1972, page 188. Zysow continues. This study throughout is concerned with formal sources in Salmon's sense. Needless to say, the Muslim formalists bear no relation to the formalists of Anglo-American jurisprudence. These jurists are contrasted with the instrumentalists. On this topic, see Robert Samuel Summers, Instrumentalism and American Legal Theory, Cornell University Press, 1983. Stay tuned for Chapter 1 and many more parts.